Hello, welcome to today's webinar on sexual harassment in connection with work and what the new changes mean for employers. I'm Lauren Hill and I'll be your host today. Before we get started, I would like to take this opportunity to acknowledge the traditional owners of the land on which we meet today and their elders, past, present and emerging. So late last year, there were a number of new amendments that was passed to the Fair Work Act. Part of these key changes to the framework for sexual harassment was in connection with the workplace. These changes do impact the way employers manage their workforce, and today, Mazars industrial and employee relations and psychology experts, Cheryl Ann Laird and Jan Flajul, will talk us through these. This includes an overview of the changes to the Fair Work Act, what employers need to consider when assessing all reasonable steps to meet their obligations, key work health and safety considerations, and also practical tips to manage the risk. So, with that being said, I'd like to formally introduce our first speaker, Cheryl Ann Laird. Cheryl Ann leads our team of highly skilled and experienced consultants and has an enviable reputation as a leading human resources and industrial relations consultant to clients both in the private and public sector. She has built her consulting success on forming long-term partnerships with her clients and has become a trusted expert who is considered to be part of the client's team. Cheryl Ann celebrates client success along with them, but more importantly, she's in the trenches with them when things get tough. She is not a fair weather consultant. Cheryl Ann brings to her consulting years of practical experience as an industrial relations expert and human resources director, along with an eclectic yet relevant list of tertiary qualifications, including psychology, business, and law. Over to you, Cheryl Ann.
Great. Thank you very much for that very generous introduction, Lauren. So my part of today's session is I'm going to talk to you about what are the amendments to the Act and how do they affect your workplace. So importantly, when did it all start? Okay, so look, the employer's responsibility to provide a safe workplace has not changed. However, the level of accountability for sexual harassment in connection with work has changed. From the 6th of March, which was the implementation date of these provisions as part of the Fair Work Amendment Secure Jobs Better Pay Act, commenced. So this is what the law now says about how you as employers or employees need to manage in terms of sexual harassment in connection with work. The new provisions seek to implement the recommendation 28 from the Respect at Work report by prohibiting sexual harassment in connection with work. The protections extend to prospective workers, so people who are applying to come and work at your organisation, and also includes sexual harassment perpetrated against a worker by a third party, such as a customer or a client. So the provisions are quite broad. The definition of sexual harassment which has been adopted by the Fair Work Act is that which is currently contained in the Sex Discrimination Act. Sexual harassment, in accordance with that definition, is an unwelcome sexual advance or request for sexual favours to the person who is harassed, or other unwelcome conduct of a sexual nature in relation to the person who is harassed. To be sexual harassment, it has to be reasonable to expect that there is a possibility. It sounds a bit convoluted, but it gives you an idea of the somewhat low barrier that applies. So it just has to be reasonable to expect that there is a possibility that the person being harassed would be offended, humiliated, or intimidated by the behaviour. This means that whether behaviour is sexual harassment depends on how a reasonable person would interpret the behaviour in that situation. As I'm sure you've probably guessed, because of that, sexual behaviour that is sexual harassment in one situation may well not be considered to be sexual harassment in a different situation. It's very contextual. One of the things that isn't contextual, however, is that when working out whether certain conduct is sexual harassment, the intention of the alleged harasser doesn't matter. Over the years, I've probably been involved in hundreds of investigations into allegations of workplace harassment, and of those, I would suggest a vast majority, when you get to the person who's been accused, they say, but that's not what I meant. I didn't mean that. They've misunderstood me. That doesn't matter. If objectively considered, the conduct has the possibility that the person would feel that they are offended, humiliated or intimidated, it doesn't matter that that's not what you intended. Sexual harassment also does not have to be repeated or continuous, so it's not like workplace bullying. It can occur on a one-off incident. Earlier amendments to the Fair Work Act had already clarified that sexual harassment can be considered serious misconduct and therefore can be a valid reason for dismissal. I think that the changes that have been happening incrementally in this space should give people a good idea that this is now considered to be an incredibly important obligation of employers to prohibit sexual harassment. The meaning of a worker, so who's covered, in relation to sexual harassment in connection with work is the same as it is under the workplace health and safety legislation. That's particularly important because the workplace health and safety legislation has a much broader definition of worker than most other pieces of legislation. So a worker in relation to sexual harassment extends not just to what we would consider to be the traditional employees, but also contractors, volunteers, subcontractors, outworkers, apprentices, and a training arrangement, so a student doing work experience would also be caught. The scope of the provision is in relation to a worker in a business or undertaking, a person seeking to become a worker in a particular business or undertaking, but also to the person conducting the business or undertaking, so employers themselves, senior management, directors of organisations are also captured under this legislation. So, what are the scope of these amendments and what do they actually mean? A substantive change from the 6th of March is the scope of the application of these provisions. Until 6th of March 2023, the prohibition on sexual harassment applied only to sexual harassment at work. However, from 6 March, the prohibition relates to sexual harassment in connection with work. Although this is clearly an expansion of the scope, it is perhaps not as dramatic as it might initially appear to be. It is clear from the previous case law that the Commission did not restrict itself in its jurisdiction to events which might narrowly be considered to have occurred at work. This was explained in the case of Bowker and DP World Melbourne, where the full bench in that case said the concept of being at work includes both the performance of work at any time or location and when the worker is engaged in some other activity authorised or permitted by their employer. Further, a worker does not need to be performing actual work for the bullying or harassment to have a clear and temporal connection to work. However, it is anticipated that the change in wording will expand the scope further. Although we don't have any case law, because the provisions have only been around since the 6th of March, so we don't have any case law on the actual new wording of the Fair Work Act. It is not wording that is unique to the Fair Work Act, and therefore we can get some guidance from other cases. So in the case of South Pacific Resort Hotels and Trainer, in that case, the full court of the Federal Court, when interpreting a similar provision in the Sex Discrimination Act, said that it is consonant, that its purpose to read the words in connection with the employment of the employee as requiring that the unlawful acts in question be in some way related or associated with the employment. We would also anticipate that the body of case law, which has developed particularly in the unfair dismissal jurisdiction, on when there is sufficient nexus to work, that conduct outside of work can be relied upon to take disciplinary or dismissal action in relation to an employee, will be relevant when considering what is in connection with work. Commissioner Reardon, in a very recent decision from the 18th of April, has kindly set out the current position regarding the out-of-hours conduct in a case called Adam Thompson and Venetia Australia Proprietary Limited, in which he quotes from the seminal case of Rose and Telstra, which still has application today. So if we're looking at what is in connection with work, what the case law tells us is that it is clear that in certain circumstances an employee's employment may be validly terminated because of out-of-hours conduct. However, such circumstances are limited, and we expect these same limitations are likely to apply. The conduct must be such that, viewed objectively, it is likely to cause serious damage to the relationship between the employer and employee, or the conduct damages the employer's interests, or the conduct is incompatible with the employee's duty as an employee. In essence, the conduct complained of must be of such gravity or importance as to indicate a rejection or repudiation of the employment contract by the employee. Absent such considerations, an employer has no right to control or regulate an employee's out-of-hours conduct. In this regard, the commissioner was, the judge noted that they also agreed with some comments made by another judge in McManus and Scott Charlton, where that judge had said, I am mindful of the caution that should be exercised when any extension is made to the supervision allowed an employer over the private activities of an employee. It needs to be carefully contained and fully justified. An employee is entitled to a private life. The circumstances in which an employee may be validly terminated may be because of their conduct outside of work are limited. So although it is clearly an extension of where conduct might be in connection with work, it doesn't mean that employers have to look at all aspects of a person's personal life. There does have to be a very clear connection with work. The test I just spoke about was actually further refined in another case. And I think it's also relevant to kind of understanding what the scope may be. In that case, it was stated that it is axiomatic that for conduct to indicate a rejection or repudiation of the employment contract, that out-of-hours conduct must be sufficiently connected to the employee's employment. Not every connection between out-of-hours conduct and employment will constitute a valid reason for dismissal. Keep in mind these are cases about dismissal, but we anticipate that the principles will be applied to in connection with work. What is clear is that to determine whether conduct engaged in privately, out of hours or outside work has a relevant connection with employment to constitute a valid reason for dismissal, it is necessary to consider the entire factual matrix. It will include matters such as the nature of the out-of-hours conduct and what it involved, where the out-of-hours conduct occurred, the circumstances in which the out-of-hours conduct occurred, the principal purpose of the employee's employment, the nature of the employer's business, express and implied terms in the contract of employment, the effect of the conduct on the employer's business, and the effect of the conduct on other employees of the employer. So, as you can see, it is an extension, but there still needs to be that very clear connection between the work and the conduct, or the employment relationship and the conduct. The changes that have been made don't only affect the scope, they also increase the risks for an employer to be found to be vicariously liable for the conduct of their employees. Vicarious liability under these new provisions arises where the principal, so that will often be the employer, the director, senior management, cannot prove that they have taken all reasonable steps to prevent the employee or agent from doing acts that could be considered to be sexual harassment. All reasonable steps. What does that mean? We don't know. Okay, and it's going to be very contextual. In the case of Von Scholler and Boral Timber, the full court of the Federal Court considered a similar provision in relation to the Sex Discrimination Act. Here it was said that an employer or principal will not be liable for the act of unlawful discrimination or sexual harassment if the employer or principal establishes. Keep in mind, we keep talking about them establishing it. So it's not one of those things where someone has to prove you've done something wrong. You have to prove you've done the right thing. But it's where you establish that it took all reasonable steps to prevent its employee or agent from doing the relevant act. The word all is significant. It is not enough for the employer to demonstrate that it took some of the reasonable steps available to prevent the employee from doing the unlawful act. However, it is unnecessary for the employer to take all steps necessary to prevent the employee or agent from doing the relevant act. What must be taken is all steps that are reasonable to take. What steps are reasonable will depend upon the whole of the circumstances, including the size of the organisation, the nature of its workforce, the conditions under which the work is carried out, and any history of unlawful discrimination or sexual harassment. I just want to emphasise that last one, which is if you've already had a case and you've not used that case to examine what you could have done differently, it's going to be very difficult to defend any subsequent claim for vicarious liability. So it's really important that if you are an employer who has had one of these sorts of claims made against one of your employees or against you as a business, that you actually look at that and you say, what are my learnings? What can I do differently? The reasonable steps taken must be to prevent the employee or agent from engaging in the unlawful discrimination or sexual harassment. The focus is upon preventative steps taken before any relevant act occurs. However, in some circumstances, the way a complaint is dealt with after the act may have relevance to the question of whether all reasonable preventative steps were taken. For example, a failure by an employer to comply with policies for investigating and dealing with complaints may be reflective of a workplace culture that tolerates unlawful discrimination or sexual harassment. Further, the focus must be on what steps would or might prevent an employee from doing the relevant unlawful act. Section 1062, which is a very similar provision in the Sex Discrimination Act, which was the subject of this case, requires the taking of all reasonable steps to prevent the employee or agent who did the unlawful act from doing acts of that kind. The employer must demonstrate that the steps it relied upon were adequately communicated to the particular employee who did the unlawful act. So I'm sure Jan's going to talk about this. It's not a great policy that sits on the shelf and nobody reads, not going to really help you. Where the employer relies upon workplace policies, it may be necessary to demonstrate not only that the policies were communicated to the relevant employee, but that they were periodically reinforced. So we don't actually know exactly what all reasonable steps are, but we do know it's not everything that you could ever possibly consider. So what is the expanded jurisdiction of the Fair Work Commission? Because that's the other aspect of this legislation. Employees who believe that they may have been sexually harassed may make an application to the Fair Work Commission. The new jurisdiction will be similar to its powers in general protections jurisdiction. Unlike the prior stop harassment jurisdiction, so it's not a new jurisdiction of the Commission, where the Commission could issue orders to stop future harassment, the new jurisdiction allows the Fair Work Commission to make orders directed to remedying past harm caused by sexual harassment, including monetary compensation. The types of orders that the Fair Work Commission can issue are compensation, monetary compensation, payment in relation to lost remuneration, so someone may have had to take a period of leave after an event, which they may seek to recover if they've taken annual leave, they may seek to recover their annual leave, or they may have had to take unpaid leave. Or to carry out a course of conduct to redress loss or damage suffered by the aggrieved person. This, I think, will prove to be very similar to what the Stop Harassment orders under the previous legislation sought to achieve. The Fair Work Commission may also express an opinion about if the applicant has been sexually harassed or if there has been a breach of the vicarious liability provisions of the Act. Importantly, the Fair Work Commission's initial jurisdiction does not include arbitration for sexual harassment disputes. However, once the Commission is of the view that all reasonable attempts to resolve the dispute have been exhausted, they may issue a certificate to that effect. The parties may then agree to the Fair Work Commission proceeding to arbitration, or the applicant can use the certificate to progress an application in a competent court. These amendments preserve the concurrent operation of state and territory laws dealing with sexual harassment. And the final one is, just in case it wasn't sort of enough, this is a civil remedy provision. So contraventions of the prohibition of sexual harassment attracts a civil penalty. It's up to 60 penalty units for an individual and 300 penalty units for a body corporate. So there's lots of motivation about why employers should take this very seriously and be looking at how they can meet their new obligations, and particularly how they can avoid becoming vicariously liable for the conduct of their employees or their agents. And I think that might be it for me. Back to you, Lauren.
Thanks, Cheryl-Anne, for that. I'd now like to introduce you to our second speaker, Jan Flajul, Senior HR Advisor. So with a strong business acumen and extensive experience in people management within the public, private and not-for-profit sectors, Jan provides a practical and tactical approach to company culture that helps organisations place people at the centre of their business excellence and commercial success. Jan holds a tertiary qualification in HR management and a Masters of Education, majoring in psychology and sociology. Over to you, Jan.
Thank you very much, Lauren, and thank you, Cheryl-Anne, for that very comprehensive and a little bit scary, we have to admit. We're all not quite sure that all word means, so please don't ask us. We will not be able to answer that question. My role is really to try and tackle the practical aspects. So to give you some tips, some solutions. And when I looked at all the changes, I felt that the first thing we could look at objectively is what is already there for you to work on. And the WH&S Act, the Uniformed One, and the WH&S Act for Victoria are quite extensive. They are bringing a lot of solutions to the problem that we're now facing. And what is important to say is that there was a recent update on the 1st of April 2023 for the WH&S regulations on how to manage psychosocial hazards. Now, psychosocial hazards is basically the hazards that can lead to a mental injury. So that's in plain words. And it came into effect in the Commonwealth jurisdiction. So what is safe to assume is that although there are different WH&S and WH&S regulations, it's universally accepted when we're talking about psychosocial hazards. These regulations, they will help you to get greater clarity on existing requirements to manage psychosocial risk under the WH&S Act. The duty holders must manage the risk to both physical and psychological health, so far as is reasonably practical. And I think that's really the key. It's so far as is reasonably practical. As Cheryl explained, It's not about all, it's about all reasonable steps. And the word reasonable is as important as all. To add another layer, in December 2022, there was a new positive duty on employers and persons conducting a business or undertaking PCBUs to eliminate workplace discrimination and harassment. And the Anti-Discrimination and Human Rights Legislation amendments, called the Respect at Work, which was led by Commissioner Jenkins, amended the Sex Discrimination Act 1984 by introducing a positive duty on employers on PCBU to eliminate workplace sexual harassment, sex discrimination, and sex-based harassment, as well as conduct that amount to subjecting a person to a hostile workplace environment on the ground of sex, and as well as certain acts of victimization and retaliation. Next slide, please. And next slide again. Now, next slide again. We're talking about the context, and this will actually explain why it's coming from everywhere, right, left, and center. The reason why is because, let's look at it from a purely human point of view. When we are in 2023, and still to the day, almost 2 in 5 women and just over 1 in 4 men have experienced sexual harassment at some point in their life. And when you look at the survey that was actually conducted, 85% of women and 75% of men who experienced sexual harassment in the workplace did not make a formal report complaint. That's very simple. That's because people don't feel safe to do it. So our responsibility as employers and representatives of employers is, as you know, to give a safe and healthy workplace environment to our workers. So part of that is that they need to feel safe to report when someone is actually displaying harmful behaviors. Another sad fact is that 23% of respondents to a survey conducted by the Australian Council of Trade Unions explained that they experienced sexual harassment in the workplace in the past year. That's 1 in 4 people, nearly. Now, when you look at the cost of workplace sexual harassment to the Australian economy, it's estimated to $3.8 billion per year. And if you look at the recent article in The Age regarding work cover and how it's on the verge of breakdown, it's just not sustainable. And there is a logic to that. A mental health claim and sexual harassment will lead to mental injuries. It's costing nearly 5 times more than a physical claim. And you cannot say, well, it's just mental health, so we should not really look after it. Health is health. There is no difference between a physical injury and a mental injury. It's an injury. So we need to do everything we can as employers and PCBUs to prevent the injury from happening. And that's what this is all about. Next slide, please. So we're going to talk about WH&S and OH&S responsibilities and obligation. Next slide, please. If you look at this scale, you can position yourself and you can say, if you're a startup, you pretty much have nothing in place. Well, you've got nothing there to help you. And then you're going to have to progress. And the only way where you're going to feel comfortable is when you have everything in place that is reasonably practical to prevent sexual harassment in the workplace. In the past, I think that sometimes there was a bit of confusion around the fact that if you are proactive and you've done nearly everything you can, then there will be an understanding that, okay, if you've done everything you can, then you should not be vicariously liable. Well, the case Von Schuller versus Ellen Taylor actually totally disputed that. It went from non-vicariously liable and moved into vicariously liable later when the judge ruled, as Sharon explained, that the word all was significant. So the employer did not take all reasonable steps. And that's really where the buck starts and where the work starts for you. Next slide, please. So how do we meet these obligations? First, we've got to identify the psychosocial hazards. So these hazards that will lead to mental injury. And you've got a lot of things that you can look at. You can look at your data. You can look at your history. And you actually must look at your history. Have you had sexual harassment claims or incidents that you've heard of in your workplace in the past? Get some consultation process in place. Seek feedback from the employees. You need to identify who may be the primary target of harmful behaviors. That is really important. LGBTQI plus employees. Do you have also a gender inequality? So do you have a vast majority of, for instance, men in the workplace and a minority of women? Are they more at risk? You need to take all these into account. But you also need to understand what type of harmful behaviors, including sexual harassment, could be displaced in the workplace. Now, there are some very obvious ones, the very overt one, verbal or physical gender violence. That's pretty crystal clear cut. We know that this is not acceptable. But when you talk about toxic culture, when you talk about the vibes, it's very hard to actually put the finger on that and really pinpoint where the problem is. But one thing that is really important, as employer or representative of the employer, the standard that you are going to walk past is the standard that you're going to accept. That standard, this is your job to define that standard. This is your job to promote and model that standard. And this is also your job to implement processes and procedures and policies that are going to match that standard, and then to monitor the effectiveness of the measures that you have put in place. Next slide, please. So once you've identified the hazard, you need to identify the factors. What are the contributing factors that may increase the risk of sexual harassment? You've got two types, external and internal. The external ones, if I'm sending my employees to a workplace that is outside of our premises, is it going to be creating more risk for them? I'm using the example of people flying in, flying out, sent to the mines. Is it going to create more risk than if they are actually doing their auditing work right here in the office? Clients, customers, patients, is this creating more risk? Internal factors, they're the indicators of workplace gender inequality or online versus physical working environment. It is well known that online work is very difficult to monitor. That's where a lot of covert behaviors, unacceptable behaviors can happen. Do you have systems in place to monitor and address these? The toxic culture. Have you actually really looked at and surveyed your employees to know exactly how they feel? Are they really happy when they come to work? These are hard questions, but they're the ones that really are going to help you to create a safe environment and a healthy environment for that matter. Next slide, please. One thing that is really important for you to understand is that when you're going to try and identify factors, when you're going to try and establish these standards, you need to accept that you have unconscious biases that are going to rule your interpretation of what you see and how the world is looking like around you. I really like that definition, and I could talk about unconscious biases for the whole webinar, and it's actually a whole training in itself. But the definition says that unconscious biases are the subtle instances where we misrecognize and misinterpret behaviors, and it causes us to overlook things. So that's the example of when you walk past and you see some behaviors, and it's not even in your radar, because in the little social box, you've put that behavior as acceptable, and you can't even see it anymore. So you need to also now, you need to take a step back, and if I'm jumping to conclusion, or if there is something that is happening, have I really observed properly? Have I taken everything into account? I'm taking one very quick example. Two people that are having a good joke, good banter, they're both laughing. So under the definition of sexual harassment, it doesn't look like it's unwelcome. But would it be sexual harassment? Do I need to address that? Well, what if it wasn't me walking past? What if it was someone else? With that joke and that very sexually explicit gesture that these two people are having, would it be acceptable? Well, it could, under the definition, it could intimidate, humiliate, or, and I forgot the last one, sorry about that, but it clearly would tick the box of, this is sexual harassment. So that's where you need to have this conversation with the people, and you can keep that one low key. You can say, hey guys, I know you're having a good laugh, no harm done here, but what if it wasn't me walking past? What you want them to be aware of is to be aware of their surroundings. Have this sense of awareness that you're in the workplace. You can joke about everything, just not everywhere and with everyone. And this place is probably not for that joke. And that's where you leave it. But don't forget to record that. You've addressed the problem, you document that you've addressed it, and you can leave it to that if there was no harm done. But you need to address it. If you see it, say it. Speak up, call out. These are the behaviors that need to be systematic in the workplace. And you need to make sure that your employees feel safe to call out and speak up. It's not just the duty of the managers to do that. It's the duty of everybody, because remember, OH&S, WH&S is everyone's responsibility. Next slide, please. Now, once you've assessed, you need to prioritize the risk. So you probably looked at for physical hazards, you looked at the risk matrix, but it's exactly the same one you are going to use. What's the likelihood of sexual harassment happening in your workplace? What is the severity of the consequences, the possible injury outcome if sexual harassment was to happen? Have you put the right control measures in place? And then you need to review the effectiveness of the controls and the measures that you have put in place. And especially if you have an incident, you absolutely must reassess. Clearly something went wrong in the process. Could we have done better? Well, you need to ask yourself the question, you need to pull the metrics back out and look at the incident and reassess again. Next slide, please. Now, there is a very quick case study. Imagine that this is a servo in the middle of Whoop, middle of nowhere. We know we've seen them all. It's night, I need my petrol, and there's just one employee there. Well, this is a pretty easy to work on environment. You basically know that that person is by themselves. Just down the road, there are pubs or clubs. Police is about 40 minutes away because it's a small village. All right, well, then it's pretty easy. You need to put systems in place to mitigate, minimize, or eliminate the risk of sexual harassment. So you need to ask yourself the questions. Is this an acceptable level of risk if I put that person working alone, open doors, and people walking in and out? No, it's not. And we know that now, very often when you drive through these little villages with the servos open at night, you can see that it's prepaid, you don't walk in, if you want something, you ask through the window. There's CCTV cameras everywhere. Very easy. Now, take that away and replace it with a Christmas function. And then all of a sudden, you've got exactly the same problem. The Christmas function, the way you're running it, is this an acceptable level of risk? Have you put control measures in place to minimize the risk of sexual harassment? What are the contributing factors? Alcohol, people around, members of the public mixing with the employees. What could be the immediate solutions to minimize the risk? Well, you can ask us these questions. We've got the solutions for you. And I'm not going to go into the detail, but there are plenty of things you can do to still have a good time and minimize the risk. And the last question, could you be found to be vicariously liable if there was sexual harassment? Absolutely, if you have not put all reasonable steps in place. Next slide, please. So, how do you implement these control measures? Well, to prevent the incident, the first thing And you tapped into that, Sherilyn. Thank you. Let's have the policies in place. The time when you just had a sort of one paragraph policy that covers discrimination, harassment, and bullying in the manual is gone. Forget about it. You need to have very precise policies that address each aspect separately, because the consequences are different, the rules are different, definitions are different. So you need to also, in the policy, give some subject matter for the employees to be able to find how am I going to deal with it? What am I going to do? It's not just the rules and the consequences. Help your employees to find their way through that and navigate. You also need to assess physical, online, safe working environment. How do you make that happen? Do you have effective communication systems? I remember an employer that was talking about trying to help the employee not being aggressed all the time, and that was in a medical practice. And we were asked to do training on resilience, help that person to diffuse or to cope and become more resilient. The first thing I asked is, have you looked at your system? People were double booked all the time. Well, here was the problem. You solved at the source. Have you got the right systems in place? You need to also equip your employees with the knowledge required to recognize sexual harassment. It's not that easy. When I put people through the test, I'm always amazed. I tell them, you've got now 5 minutes to write the 5 steps. How are you going to address when you're walking through a work function that you're in charge of? You're an employee, you turn around, there's no managers there, but you see sexual harassment being displayed. How do you address that? What do you say? What are the words you're going to use? Are you going to create a whole scene, which is going to make it worse? What is the test? All these little things that you actually need to be real about, that's what you need to give to your employees. You also need to give your employees the skills required to respond if they are personally sexually harassed. How do I say that? You need to help them to feel empowered and feel safe. So then you need to ensure that all these control measures are most effective to prevent sexual harassment from happening. Next slide, please. You need then to put in place, as Sherilyn said, control measures that will help you to address the incidents. When they're happening, you need to actually follow a protocol, and that needs to be compliant with the regulation. So you need to provide easy to follow processes for reporting incidents. I'm always, again, amazed at the amount of time when I go and there is no complaints and grievance procedure policy. Well, that means you're not giving any chance to yourself for an employee to follow your process. So what do? They go straight to Fair Work, because that's the only recourse they have. You need to provide internal contact names for reporting and the ability for people to have just a confidential chat. You need to provide also external contact details or agencies to support people that have gone through. And that's the victims, the witnesses, and do not forget the perpetrators. Because what Sherilyn rightly said is the intent is totally irrelevant, but the reality is that very often people are mortified about their behavior once they realize that they've done the wrong. So you need to actually help them to get through that. And you need to really help them to be educated on how to behave properly. You need to also have systems in place to monitor behaviors after the incident. You can't just address the incident and expect that everything is going to go back to normal, because there will be ripple effects. You need to monitor that for a period of time. And then, first and foremost, if something happens, you need to check what more you could have done for this incident not to happen. Next slide, please. Now, one of the key aspects is training and education. You need to train your staff on what to do if they're subjected to sexual harassment, what to do if they witness or hear about sexual harassment, and what to do if they are accused of sexual harassment. And basically, if you're accused of sexual harassment, the first thing you need to learn is take it very seriously. This is no joke. You could lose your job, and you could go through civil court. Next slide, please. You also need to train your managers. That's another layer to the training. So you train your staff. That's very important so that they understand the rules, the consequences, and how to feel safe or recognize when there is wrongdoing. But you also need to train your managers on how to model acceptable behavior, how to promote the company values, how to set the standards, but also how to identify the risk and the factors, how to recognize sexual harassment. The test, it has to be unwelcome, have to be of sexual nature. And under reasonable circumstances, you should have known better. You should have known that this behavior would humiliate, intimidate, or victimize. You need to help them to understand how to manage the incidents and follow procedures in place with set reporting system, how to apply procedural fairness, separation of duty. Investigators cannot be decision makers. And also how to accompany and support the victims, the aftermath, how to monitor the impact on the team. Because yes, you're gonna try and keep it confidential, but we know that things will be known. And if it is, how do you monitor that to make sure that there is no retaliation, no victimization, but also no impact or limited impact on the rest of the team? Next slide, please. Thanks again. Next slide, please. Now, the last thing you need to do is really to make sure that you consult. And that's where you start. You remember when you do your risk assessment, it always starts from the ground up. So you need to have this consultation with staff. And you need to discuss the significant impact that sexual harassment can have on your employees. Equally, you need to discuss the significant impact that sexual harassment can have on your organization. So as far as the employees are concerned, safety is the number one. This is the impact because it will create an imminent risk to the health and safety of the person. The impact on their mental health, the potential long-term stress, anxiety, depression. Remember the pyramid of Maslow, the needs. After the physiological needs, the next one, safety. If you don't feel safe, don't expect people to actually provide productivity, to be productive at work, if they don't feel safe when they walk in the environment. But also when you talk about retention, how hard it is nowadays to keep your staff, well, that is part of that. That's part of the job satisfaction, the engagement, the productivity. All these things will be impacted if people feel that they are not safe. From a company point of view, remember the impact, the reputational damage, the cost, the underlying cost behind a sexual harassment or a toxic culture for that matter. Next slide, please. Finally, this is a really important thing. Remember the figures, 85% of people do not report. You need to have that conversation with people. That's part of the training. Why do staff not want to report incidents in your workplace? Here is a list. I invite you to have a look at this when we send you the slide deck. This is also a subject of conversation you need to have with your staff. They need to feel safe. They need to feel supported. And then they'll be able to make your organization safer and support your organization to set the standard. That is it for me. I think that the last word is culture eats strategy for breakfast. Remember, what you want to set here is the standard. I will finish with that sentence that I use all the time. The standard that you walk past is the standard you accept. Make sure you never walk past the standard of any sexual harassment happening in your workplace. Thank you very much.
Thank you, Jan. That was great. Although those are some pretty scary statistics. So I think the overview of the changes in the law and the practical tips to help manage these changes and create a safe and healthy workplace will be very helpful for our listeners today. So thank you, Jan and Cheryl-Anne. So now I'd like to open up for questions and comments. So click on Ask a Question by moving your mouse over the screen and clicking the three dots in the bottom right corner. Please provide your name and email address just in case we don't get to your question today. So the first question I could see here was just a housekeeping one, which was, is it possible to get a copy of the slides only? And I can confirm yes. So all registered attendees will receive a copy of the recording and the slides after this. So I have a question from Rob here. Do we have to train staff if we are just a small business? So, Gian, you want to take that one?
Yeah,
Perfect.
I might take that one. Well, ask yourself the question, how many staff does it need to actually be right? You remember that ad when someone was asking how many people dead on the road due to road accidents is acceptable? And the guy was saying, I don't know, 20. And then they were pulling the screen behind him and he had a look and there was 20 members of his family. I think that answers the question. Any size, you need to train your staff because it just takes one employee. That employee is subject to harassment potentially from clients, customers. Then that's it. So is that person, because it's just one, is it not worth it? So to answer the question, the WH&S obligations are very well stated, and WH&S obligations, you need to train all staff, regardless of the size. What we're looking at is how much money, time, and resources you have. So if you're a small business, yes, we're not expecting as much as if you are BHP, but ultimately, you still have to train your staff, every single one. And remember also, when you train your staff, don't forget the new staff. So you've done the training, like, yep, I've ticked the box. And now you've got a bit of turnover, you've got 5 new staff. It will take maybe a year or 2 or 5 before you actually wonder, oh, we missed these guys. Well, these guys now, they become the risk because they could be the people that will create the problem or be the recipient of the problem.
Yeah. Lauren, I might just add there as well that there are certain provisions of the Fair Work Act which exclude or change responsibilities for small businesses, being businesses under 15 people. This is not one of them. So yes, Jan is absolutely right, but there is also a statutory requirement. There's no exemption for small businesses in this part of the legislation in relation to the prohibition of sexual harassment, and that makes perfect sense for all of the reasons Jan just talked about.
Yeah, okay. So, well, yeah, those were both really great answers. Thanks for that. So my next question on the chat is, so a question around witnessing harassment, but the victim not willing to report. So the question was, we're just wondering what happens with the situation where a witness sees sexual harassment, but the victim is not comfortable reporting it, or alternatively doesn't see the behavior as harassment.
These are two different, actually, situations. If they don't see the behavior as harassment, then you need to make sure that they understand what the test is, and that could help them to revise their view. But ultimately, as an employer, you have a duty of care. If you see a problem that creates imminent risk to the health and safety of your employees, you need to act. So when an employee says, well, I'm telling you this in confidence, but I don't want anything to be done, unfortunately, that's not an option. But what you need to say, and you can say, is we're going to keep this confidential. And the confidentiality is around the perpetrator, the victim, the witnesses, and nobody else. And you need to make sure that that person feels safe in that perimeter, but you cannot say, okay, I'll do nothing about it, because it's not actually an option. You absolutely must do something about it. Would you agree, Sharala?
I would.
Okay, so my next question, I think I'll address to Charlene. I think you touched on this earlier. So the question here is, do the rules extend beyond pure employees, or can the law be extended to others, for example, contractors and customers?
Absolutely. It is certainly applies to contractors in terms of the employer's liability for those. It also extends to customers in relation to your employees or your employees' engagement with your customers or clients. It's important to also mention, remember I said that the legislation doesn't change the fact that there is still state and federal legislation. So, for example, to customers in your corner store harassing each other, may well not fall within the Fair Work Act, but it would certainly be picked up under other pieces of legislation. But certainly the Fair Work Act, as it applies to sexual harassment, because they've picked up the definition of worker from the workplace health and safety legislation, is much broader than just your employees.
Okay, great. Another question got here is how much time can happen between the harassment behaviour, so the event, and when the complaint is made? Is there a time limit there?
There is a time limitation of 2 years or 24 months. There is some flexibility with that, and again, we won't know how flexible until we start to see some case law in this. But certainly it's been my experience in state jurisdictions in terms of discrimination specifically, although a lot of those were 12 months, where a person can show that there was a valid reason that they didn't bring their claim or their concerns up earlier, an extension is available.
Great. Probably have one or two more questions left to go with the timing. So one here says, you said that the commission can make orders to carry out a course of conduct to redress loss or damage. Well, the question is, what could they order?
The jurisdiction here is open. So the commissioner could order anything that is reasonable. Keeping in mind it's what they think is reasonable, not necessarily what you think is reasonable. So for example, they may require that two people not work together anymore. So they may require that the employer find an alternative role for one or other of the parties. They may require that other steps be taken to ensure that those two parties don't need to engage. Although it's certainly open to the commission to require one party apologise, the reality is that often doesn't resolve things because it's often not a genuine apology. But they could certainly also offer some forms of compensation. So until we see some case law, we're not really sure how far they're going to go. But there is certainly no specific boundaries around what the commission can in fact order to resolve these problems when they arise.
Great, thanks, Cheryl Ann. So one quick last question is, how will these new laws help me rather than hinder me? Jan, did you want to take that one?
Well, ultimately, this is not new. The answer is these are not new laws. These are principles that have always been there. And very often I get the statement from some workers that go, now you're the fun police. We cannot make the jokes anymore. And my answer is, well, you just could never. You just got away with it for too long. Now it's time that it stops. And you're going to follow the rules or else. And this is what it is. So yes, it is a hindrance. I totally accept. But ultimately, this is about being good human beings. This is about making people happy and safe when they come to work. And that's the key. So whatever needs to be done, you just need to do it.
Great. Well, I think that's all we've got time for today. So thank you for joining us. The presentation will be available shortly after we end today's webcast. You will be able to watch on demand by clicking on the same link that brought you to the live event, and we will circulate soon. Thanks again for watching. Goodbye.